Hey, everybody. Sorry about the little delay. We were supposed to start a couple of minutes ago, but had to create this new link for this live. And I'm really happy to be here today because I've been waiting 46 days for the court order that just dropped this afternoon. By way of background, Judge Hippler has put in a process where he has gone back over this case that was so highly sealed, Idaho versus Kohberger. This case ran for more than 2.5 years. It was supposed to go to trial in August, unsealing all of the information, all of the evidence that had been sealed to the public in the way of the prosecution being required to prove their case beyond a reasonable doubt. And then we saw what happened on July 2nd when Mr. Koberger pled guilty to all 5 of the criminal counts, all 5 of these serious felonies relative to 1122 King Road, as he did on July 2nd, 2025. The sentencing proceeding happened July 23rd, and the case was closed in terms of the criminal case. However, there was this issue of what I have referred to as a Mount Everest of documents that were under seal during the entire pendency of the case that still are largely under seal until today. And I want to thank you, Sonic, for coming over here and being here all the way from Australia, where it's what, Saturday morning where you are? It's still Friday afternoon here on the East Coast of the United States and a couple of hours behind over in Ada County. So anyway, getting back to this issue of the documents under seal, when Judge Hippler closed the case and Mr. Kohberger was sentenced and moved from the Ada County jail where he had been housed since change of venue happened in September of 2024, there still was this matter of all of these documents under seal. So what Judge Hippler did in August is he announced formally a process where he was going to take a couple of months at a time, starting in July and June. He said he was going to work backwards. So that was order number 1. And within 30 days, we got a ruling of that order where he started to unseal documents, June and July of 2025. Order number 2 then came out, and that dealt with April and May of 2025. After 36 days of that order, he unsealed some of the documents from April and May. Then came October 16th, 2025, in the third order. And this, when I saw this third order that he went 3 months this time, January, February, and March, I said, okay, now we're getting to, as Harsh would say, the meat and potatoes of the case, because this had to do with all of the motions in limine, all of the responses and replies, dealing with wanting pretrial rulings. That's what a motion in limine is. And they were everything from IgG DNA evidence to text messages between the surviving roommates at the time, before, during, and after the time of the crimes, and then their texts to people outside of the house and people outside of the house, texting them back, calling them back. That was one of the in limine filings. And then there were so many other things having to do with the travels of the 8458 phone, which, if you've listened to our re-looking at the affidavit of probable cause, is sometimes referred to as the 8548 phone. So we don't know if Detective Payne was looking at 2 separate cell phones to try to track suspect vehicle 1, or if it was just one. Then there was an in limine filing regarding suspect vehicle 1, bushy eyebrows. So when I saw that, I said to myself, this is an order that I want to see. So I synchronized my watch. Okay, Judge Hippler did say himself at the November 5th hearing on restitution, past behavior is a good indication of future conduct, in talking about people possibly sending money to Mr. Kohberger that he had earned, I don't know how much money, or he'd received so much money, X number of dollars from people sending him money. It was mainly his family, it seemed like. And he said, hey, in future, he could still receive some money. And therefore, I took that same concept that applied it to Judge Stephen J. Hippler. Because it took him 30 and 36 days from the time that he issued the first and the second court order, I said, okay, around 30, 36 days should be when the results of the October 16th, 2025 third order dealing with January, February, March of 2025 should come out. And it didn't. And it didn't come out in 40 days. It didn't come out in 50 days. It didn't come out in 60 days. And I put out some content the other day saying, hey, things have basically stopped. Not only is he not ruling on this, he hasn't put out a fourth court order dealing with getting finally into the end of December, November, October of 2024. That order has not come out as of yet. And he also didn't publish anything on the docket since November 13th, 2025. So finally, yesterday, we saw that the court order was rendered. There were two. One was December 18th, having to do with the state. It looks like the state was really fighting hard to get more documents sealed from the public. And you're going to see here, when you read this court order from the 18th of December that just hit the docket today, you're going to see that Judge Hippler disagreed with one or both of the parties who wanted more things under seal. And he said, hey, I can't find any justification, and there are a lot of documents. So kudos to you, Judge Hippler, for being transparent here, finally. Then this morning, it still wasn't published on the docket. So what I did is I called the clerk's office in Ada County, and I said, look, it's on the case summary page. When is this document going to come out? Because my fear was if it didn't come out today, then we're getting into next week, which is Christmas week, because court is closed tomorrow and Sunday. So the first possible day it could possibly drop, if it didn't drop today, would have been the 22nd. And then we might even get into then the closure of the courts for the Christmas holiday. So what the clerk did, very helpful, the assistant clerk told me that I should speak with someone by the name of Shannon, who was some type of a supervisor. I left a message, just basically said, hey, when is this coming out? And I know other people have called as well. And then finally, it's on the docket. I want to say hello to a few more people here. Sarah, also Dan, thanks for being with us. Without further ado, what I recommend that you do is to go to the Judicial Interest, Cases of Judicial Interest website. And when you pull up, it's got a red button next to it, new. It is the court order dated December 18th, 2025. This has to do with the unsealing of documents January, February, and March. What Hippler is referring to is he's referring to the numbers of those documents from the October 16th order. So I recommend that when you look at these documents, that you have both open, that you have the October 16th order, which is going to tell you what these numbers relate to, and you have Judge Hippler's order. I'm going to be doing a live later on, premiere content where I'm going to publish both of the orders and start looking at some of these documents. But I wanted to, at this time, refer back to the court order of the order unsealing, redacting, and or maintaining the sealed status. This is on the court docket. You have to go to Ada County case number CR 0124316665. It is the very last order on the docket, but also pull up the October 16th order. So let's look at a couple of what he's unsealing here. He says here, on October 16th, 2025, the court issued an order seeking the parties' position regarding the unsealing of the third set of documents identified here as number 88 through 179. And then he has a footnote stating that this corresponds to the October 16th order. And if you pull up the October 16th order, you're going to see item number 88 is the March 31st, 2025 state's response to defendant's proposed jury questionnaire. This was back in March, the end of March. The trial was rapidly approaching at that time. So therefore, the parties were squabbling over which should be on the jury questionnaire. And that was going to be used in the process of selecting the jury in this highly publicized case. Proposed questions to ask. Judge Hippler said that he was summoning thousands of people for potential jury duty in this case. All right, so we have the order. It says here again, On October 16th, the court issued an order seeking the parties' position regarding the unsealing of the third set of documents identified therein in number 88 through 179. The court has reviewed the parties' respective responses and rules as follows. And just by way of background, what Hippler has been doing in all of these orders is he gives both sides 2 weeks. He says, here's the documents that I'm looking at possibly unsealing. You provide me a response within 14 days, and you tell me if you have any objections to these documents being unsealed, either with redactions or without, or if you have no objections at all. And if you have objections, state with specificity what your objections are. The state responded to this October 16th order back on October 31st. It is on the court docket. You can read it, or I'm sorry, October 30th. You can read it. The defense, however, they filed their entire response under seal. This is the first time they've done that. And that is dated the 29th of October. But what had happened is it appeared that there was something that the state did. I don't know if the judge let them know in advance what he was going to unseal. The state had an issue with it. So there was November. If you look at the case summary page, November 21st, the state filed an objection to certain documents being unsealed. On the 25th, they filed a public record stating that they were looking for, without a hearing, judge, go ahead and rule on this matter without a hearing. You can see the document that they filed on the 25th. It's on the docket. And then the court order sealing that. And then comes the 18th. Here we go, the order here. So it appeared that the state wanted a lot more sealed than is being unsealed here today. Now, this order is set up in 3 parts. The first part is entitled Documents to Unseal in capital letters. And then there is B, Documents to Maintain Sealed Status. That is on page number 1. Let's look right now at Documents to Unseal. And then we're going to refer back to the order of the 16th to correspond as to what this means. It says here, Documents to Unseal, Section A. With regard to the following documents, the court received no objections by either party to their unsealing, and the court finds no further justification to warrant their continued sealed status. Document number 88. We got to refer back to the October 16th order. 88 is the March 31st state's response to defendant's proposed jury questionnaire. The next item to unseal is document number 89, referring back to the October 16th order. That is the March 31st, 2025 defendant's objections to state's jury questionnaire proposal. So what we see here is that the parties were filing under seal information regarding the jury questionnaire. Proposals here is what the state's saying. That is because, as the trier of the law, Judge Hippler would have had the final say as to what that jury questionnaire would have been. It would have looked something like, do you know any of the parties here? Do you know Mr. Kohberger? Do you know the prosecutor? Do you know any of the defense attorneys? And if so, what is your relation? Do you know any of the key witnesses in the case? Things like that, to see if potentially one of those jurors should have been stricken from possibly having a conflict. If somebody said, "Oh yes, I know Mr. Kohberger. I live next door to him. I know him from a class, and I know him very well," that probably would have been somebody that would have been struck from serving. Okay, so that's 88 and 89. That deals with the jury questionnaire proposals. Now, if we go back, document number 93 is being unsealed today. This is, if we go to number 93 on October 16th, this is defendant's proposed jury questionnaire. So again, this relates to the possible questions that the parties were offering dealing with jury selection. Then we go back and we see the next item, item number 97 is being unsealed. What is item number 97? Again, we have to go back to the October 16th order, page number 197. March 24th, 2025, States Exhibit S as in Sam, 20B, as it relates to Nord, N-O-R-D. And this relates to, it looks like one of the motions in limine. Then item number 101 is being unsealed today. What is that? We have to go to page 2 of the October 16th order. That has to do March 24th, 2025, States Exhibit S as in Sam, 15C, rebuttal. This is a rebuttal witness by the name of Ayers, A-Y-E-R-S. That's being unsealed per this order. Then if we go to document number 108 is being unsealed today. What is that? That is what we just read. Ayers is being unsealed. States Exhibit S is in 15B. Then if we see document number 111 and 112, both of them are being unsealed. That is States response to defendant's motion to adopt voir dire procedure and objection to, quote unquote, the magic question. That was an interesting concept when that came up under seal. 112, State's proposed jury questionnaire. So we're seeing here the parties were becoming readily involved with preparing for trial. And I want to say hello. We see here a lot of people. Thumbs up. Joseph, welcome. Yes, I know that you have been wanting this case to be unsealed. We're seeing it today. So basically what we have to do to understand what is unsealed is to follow the October 16th order. Now, Judge, and there's a lot more here. There's about another, it looks like 15 documents. What's interesting here is when Judge Hippler says documents to unseal with regard to the following documents, the court received objections by one or both of the parties prior to unsealing. However, after considering the objections, the court finds no further justification to warrant their continued sealed status. So good for you, Judge Hippler. It appears here that one side, that would be the state or the defense, or both of them together, wanted the following documents to remain sealed from public disclosure. The first one on the list here is item number 95. We got to go back to the October 16th order to find out what the state or what the defense wanted to be sealed from the public. Document number 95, March 24th, 2025, States Exhibit S as in Sam 23B, as it relates to a witness by the name of Walthall, W-A-L-T-H-A-L-L. Sorry, state. Sorry, defense. Whoever objected, Hippler has overruled you. That is going to become unsealed to the public. Next document that one or both of the sides had a problem with unsealing to the public is document number 99. And what is 99? This is March 24th, 2025, States Exhibit S as in Sam, 18B, as it relates to Martinez. Person by the name of Martinez, Part 1. Sarah, I see that you're in chat. If you know who any of these people are off the top of your head, please feel free to include that information, or if anybody else knows who they are. Then we see, what I want to do is I want to go back to the older documents here that they had a problem with, because those are going to relate, I believe, more to the in limine filings. I hope. I'm reading this with you for the first time. And so if we go down to find the end of the documents from 175, 177, we have to go way down on the October 16th court order. And this is going to appear page number 5. Now, someone had a problem with document number 177 being released to the public. 177 is a January 2nd, 2025 Exhibit T to defendant's 21st supplemental request for discovery. Bingo. We're going to finally find out what it was that the defendant was serving in this 21st supplemental request for discovery upon the state. Now, why is this important? When you see discovery, think evidence. Discovery is something that one party will serve on the other side, believing that this information is on the other side's custody, possession, or control. that will help them in this case, in the defense of Mr. Kohberger. From the beginning of the case, what both of these sides did is they served discovery. You can go back to discovery request number 1, January of 2023. The defense filed the first request for discovery. And what they did is what hit the docket is that a discovery request was served, but what they were asking for was in an exhibit. Exhibit A, Exhibit B, Exhibit C. So Exhibit T means that they went that far through the alphabet to Exhibit T, asking for evidence that was in the possession, custody, or control of the state. And one of these sides, or both, didn't want this information to come out to the public. So I say again, thank you very much, Judge Stephen J. Hippler, for overruling that. We're going to finally see what some of this evidence was. 172, 171, and 172. One or both of the parties had a problem and didn't want this to be submitted, to be unsealed to the public. What is document number 171? Oh, okay. This is, who knows who Lawrence Mowery is? This has to do with Detective Mowery. The magic question. We're going to find out. We're going to find out, Sonic, when we finally are able to see some of these documents that have been under seal. Okay, Lawrence Mowery. Does his name ring a bell? Have you seen any of the recent interviews, quote unquote, of some of the witnesses, the surviving roommates? Lawrence Mowery was involved in that process. He interviewed one of the surviving roommates November 13th, 2022, heavily involved in the serving of the warrants pre-arrest, post-arrest, with information that they felt would be helpful to the prosecution of Mr. Kohberger. So when we look at, Judge Hippler has basically overruled one of the parties, one or other of the parties did not want something related to Lawrence Mowery being disclosed to the public. What was it? Document number 172, January 7, 2025, amended expert disclosure regarding Lawrence Mowery, S's and Sam 10. S's and Sam 10 is being disclosed to the public today as a result of Judge Hippler's order overruling. It was either the defense or the state didn't want something having to do with Lawrence Mowery serving as an expert at trial from coming out. Sorry. And then we say item number 171. That is, okay, 171, a January 7, 2025 amended exhibit. So an exhibit was amended, and it is exhibit S's and Sam. Okay, so what happened in 72? They went ahead, they served an expert disclosure regarding Lawrence Mowery, citing to S10, and now they're amending something. They're fixing something. Because remember, expert disclosures happened in 2024. It was tied to Judge Hippler's court order of October 9th, setting the trial. That's what set the expert disclosures. So looks like the state of Idaho went back and corrected something as it had to do with Lawrence Mowery, and somebody didn't want the public to find out what that was. Again, we say thank you, Judge Hippler, in the name of openness and transparency, finally, in this case. Then we see here, somebody had a problem with document number 168 from the October 8th, 2020, the October 16th, 2024, third order. What is document number 168? Oh, okay. Something having to do with discovery, i.e. evidence. This is the January 9th, 2025 Exhibit A to defendant's first supplemental response to discovery. So this is the defense responding to the state's discovery request, and whatever Exhibit A, which was filed, which was the response, the meat and potatoes of what the state asked for and the defense is responding with, well, that was under seal until today. Thank you, Judge Hippler, for overruling whoever wanted to keep that under seal. And then we have document number 159. Judge Hippler said, sorry, state or defense, this is being released to the public. What is document number 159? Okay, this is the January 27th Exhibit S1 and S1 A through E to state supplemental response to request for discovery regarding penalty phase experts. So this is a response to discovery that was made by the defense to the state until today was filed under seal. Now let's look at document number 145. That is another document that one of the parties, the state or the defense, did not want to be disclosed to the public today. Oh, look at that. I am very interested in this, ladies and gentlemen, having just done the 18-part relooking at the affidavit of probable cause 3 years later. If you have not had an opportunity to look at that, please do, because I pinpointed to the record where it wasn't the witness, it wasn't DM who identified Mr. Kohberger by his bushy eyebrows. It was, in fact, according to the affidavit of probable cause, one Detective Brett Payne, who felt that in looking at Mr. Kohberger's driver's license, that he had bushy eyebrows, the same bushy eyebrows that DM alleged that he alleged DM saw when she encountered the stranger in black, the intruder, who she said when she spoke with the first responding officer, Nunez, you can see it, body cam was released, she couldn't even see the intruder's eye. So how is she going to see the intruder's eyebrow? So here we see item number 145, either the state or the defense did not want the February 24th, 2025 defendant's motion in limine, number 7, regarding witness identification by bushy eyebrows. There was something about that in limine filing that had to do with the identification of Mr. Kohberger by his alleged bushy eyebrows that is now being released to the public. The in limine filings were filed during February and March of 2025, and a lot of these filings have to do with them, including document number 137, 138, and 139. One of the parties, or both of them, did not want these documents sealed to the public, unsealed to the public, and Judge Hippler overruled them. What is document number 137, 138? Okay, 137 and 138. February 24th, defendant's motion in limine number 14 regarding statistical analysis, and 138 regarding defendant's motion in limine inconclusive data that had to do with a lot of the evidence that the state was seeking to introduce at trial that the defense keep. So we see quite a bit of information here that's being unsealed to the public for the first time, ladies and gentlemen. Any thoughts, any opinions? Oh, Christopher, thank you very much. Love you too. This is an excellent synopsis. Well, I appreciate. Oh, Miller time. Miller time. Did you think this day was ever going to come? I, for one, thought that we would be going into maybe the new year before any of these documents would be unsealed to the public. Day 64 as opposed to day 30 and day 36. So again, we're going to be doing a presentation. It'll be a premiere later on. I'm going to be working on this all weekend. This is a lot of information here. Got to digest everything, but just wanted to go over a synopsis. And again, what I recommend that you do, because we recommend that you read the documents for yourself. Don't take my word for it. Don't take anyone else's word for it. You are perfectly capable of reading these documents, and you're going to need two. You're going to need the December 18th order finally entered today on the docket that says what Judge Hippler has said is going to be unsealed to the public, is going to have redactions, and what will remain sealed to the public. He's only identifying them by numbers. So you got to have the October 16th third court order open, because that's where he says, like document number 88, he'll tell you what document number 88 is. All right, let's go back and let's look at, I'm really, I have to say, again, Judge Stephen J. Hippler, thank you very much for overruling whichever one of the parties wanted these documents to remain sealed to the public. Now, let's look at, we see here documents number 120 and 121. I don't know if we went over those yet, but let's do that at this time. This was, if we go back to our October 16th court order. Oh, ladies and gentlemen, breaking news here. Breaking news here. Who wants to venture a guess as to what document number 121 was? Document number 121. Anyone in the audience? Sarah, Sonic, Miller Time. I know that many of you, Joseph, I know that many of you have been very, 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 very interesting. Christopher, I think that you are on the right track. Who here wants to see what's under seal regarding AT&T timing advance records? Anybody? Anybody want to? This was the tracking of it was referred to as the 8458 phone, but then again, it was referred to as the 8548 phone. So I've raised questions in the affidavit of probable cause if they were tracking two cell phones, or if Detective Payne called the 8458 phone the 85458 phone by accident twice. Yes. Oh my gosh. Let's go back here. And the best part of this, Christopher, is that one or both of the parties did not want this released to you. They didn't want the public to see this. Let's go back. Okay, remember, Judge Hippler has said, with regard to the following documents, the court received objections by one or both of the parties to their unsealing. That means that when Judge Hippler entered that October 16th order and said, state, let me hear from you, defense, let me hear from you, I want you to tell me if you have no objections and we can go ahead and unseal these documents, or if you have an objection and state with specificity what that objection is. Okay? So again, with regard to the following documents, the courts received objections by one or both of the parties to their unsealing. However, after considering the objections, the court, that's Judge Stephen J. Hippler, finds no further justification under ICAR 32 I3A. That is a rule of court, ladies and gentlemen, legal authority cited to keep this information from getting to the public, to warrant their continued sealed status. So he has overruled one or both. Let's go back. We've got to go back to, it's page number 2 of the October 16th, 2025, aka the third court order that yours truly has been waiting for a very long time. Document number 121, March 17th, 2025, exhibits 1, 2, and 3, previously under seal, to defendants' objections to state's motion in limine regarding AT&T timing advance records. Once again, one or both of the parties objected to Judge Hippler unsealing this document. He said, sorry, I see no reason to keep it sealed from the public. This is the March 17th, 2025, exhibits 1, 2, and 3 to defendant's objection to state's motion in limine regarding AT&T timing advance records. I don't know about the rest of you, but I'm making a beeline for this document immediately, if not sooner. I'm wondering if this could be any of Cyray's testimony or documentation, because this is a defense exhibit to the AT&T timing advance records. Yes, Blue Devil, 95 Blue Devil, lots happening in March. March is when the responses and the replies to the in limine proceedings, as well as to discovery, many of them were filed. Ladies and gentlemen, I would really appreciate if you haven't already, please subscribe to the channel. Please hit that like button. It will really help us to grow, to get the facts, not the fairy tales, out about this case. Highly under seal. Now, somebody had an issue with another document here, another in limine filing. And again, motion in limine, what's a motion? Motion is an application for a court order. In limine seeks a ruling pre-trial, before trial. So motion, one of the parties is asking the court to enter an order in limine prior to trial. Document number 121 had to do with AT&T timing advance records. What's document number 120? Who had a problem with this one? I want to know. All right, 120, we go back to our trusty October 16th third court order. Document number 120 is listed as March 17th, 2025, exhibits 1, 2, and 3 to defendant's objection to state's motion in limine regarding admissibility of demonstrative evidence. Now, when I hear demonstrative evidence, okay, this means that the state wanted to use some type of something. Could it have been maybe the sheath that they purchased? Remember, the state purchased a K-bar sheath. They supposedly sent the original K-bar that was found on the bed with Madison and Kaylee on the third floor, either on the left side of Madison and Kaylee, if you believe the detective from Idaho State Police who was put in charge of crime scene processing, or on the right side, if you think that Detective Brett Payne got it correct. Could that be the demonstrative tool? Or might it be the quote-unquote dollhouse? Might it be the quote-unquote dollhouse? Okay, what do you guys think? We don't know, Sonic. We don't know if it's about Cy-Ray, but remember, it is the defense motion in limine. So it is the defense filing some exhibits regarding AT&T timing advance records, not the state of Idaho. This is the defense's response. Remember, when you're looking in limine, the briefings go, motion in limine, they were filed in February. The deadline for the motions in limine, I believe it was around February 17th. Then the other side has a due process right to be heard. So the second is going to be the response from the other side, objecting to, raising issue. No, Judge, you can't grant this motion. You got to deny it, and here's why. That's what this document number 121 is. It's the defense response to the state's in limine filing having to do with AT&T timing advance records. As I've said, I haven't seen it yet. I'm going to make a beeline for this document very quickly. Okay, so we have Christopher. It's unlikely the defense resisted speculatively. They left out the 1112 video from Twine. We are still waiting for that 1112 video from the very important time frame. I think it's a few minutes before 2, because that was supposedly when the very mysterious in the affidavit of probable cause private driver, because he wasn't named. His name was completely redacted by Detective Brett Payne, supposedly brought Madison and Kaylee home at 1:56 a.m., somewhere around there. And hey, we should be seeing the car turning around the corner, going onto Queen Road. We should be hearing something, because that camera has picked up audio, maybe of the car door opening, the car door closing, and then the private driver leaving. Yes, we do need, and that would have been, yes, we do need that. We need that information. Thanks when they're running it. Okay, thanks, Twine. All right, let's go back now. Let's look at, okay, so 120 and 121 were the hardcore matters regarding in limine that the court overruled. Again, 120 has to do with admissibility of demonstrative evidence. 121 AT&T timing advance records. Okay, and just again, these are objections. These two are objections. So again, it goes motion in limine filed, response by the other side in an objection, and then there's the reply. That's when we get to the replies. That's the original party who filed the motion in limine coming back and saying, Judge Hippler, no, the other side got it wrong. In their response, here's why you got to grant this filing. All right, let's see what else Judge Hippler decided should be released to the public. Oh, okay. Document number 119. This is interesting. Yes, I eyeballed this very quickly when I saw this coming up on this list. This is the March 17th, 2025 defendant's objections to the state's motion in limine regarding the 911 call. So there's apparently some information under seal regarding the 911 call that defendant objected to, that somebody didn't want released to the public, that Judge Hippler said, your objection is duly noted and I'm overruling you. I'm going to be releasing it, having to do with the 911 call. Now, this number 118 is the defendant's objection to the state's notice of intent to use IRE 404B evidence. That was a massive in limine motion. It had to do with all manner of evidence that they wanted to introduce in trial. I'll leave you to go ahead and read that when you can. That's being unsealed to the public. All right, let's go back to what else is being unsealed that nobody had an objection to. 165, 166, 167. What are these? Hopefully these are some of the in limine filings. 165. What's number 165? We go back to the October 6th court order. 165 is, drum roll please. Okay. January 16th, 2025, witness and exhibit list. Disclosure for hearing on January 23rd, 2025. Witness and exhibit list. All right, what was January 23rd, 2025? Let's go back in time. Oh, yes, that was the motions to suppress hearing and a motion for a Franks hearing. Remember when it started out, it was under seal. Detective Brett Payne got on the stand, and that's when he testified that, testified that nobody from the Moscow Police Department ever heard of a Brian C. Kohberger until when? The evening of December 19th, 2025, or 2022, pardon me. The evening of December 19th, 2022 is the first time Detective Payne, under oath on the stand in response to a question asked to her by defense counsel, when did you first hear, when did my client come on your radar as a possible person of interest or suspect? That was deemed to have been by Detective Payne as the 19th of December, 2022, at that infamous Teams hearing. Now we've received some documentation, however, released to us, the public, from Idaho State Police with Mr. Kohberger's name on a document that was submitted on December 5th, 2022 for evidence to be tested. Who submitted it? It was the Moscow Police Department. And on page 2 of that document, you had suspect number 1, name redacted. We still don't know who suspect 1 ever was. But suspect 2, Brian Kohberger's name, clear as day, December 5th, 2022, as a suspect. And that resulted in the Idaho State Police's coming out with their quote-unquote explanation. Oh, that was an error. He was not a suspect on that day. All right, so let's look at a couple more here that's being unsealed, which nobody has a problem with. Document number 146, 148. We go back to our trusty October 6th order. 146 is, okay, the February 24th, 2025 state's motion in limine regarding self-authentication of records that the defense had an objection to. Information regarding that's been under seal is being unsealed today to the public per Judge Hippler's court order. Document number 14344, go back to the October 16th third order. This I'm very interested in, I must say. Document number 143, February 24th, 2025, Exhibit 1, in support of motion in limine regarding excluding Amazon click activity at trial. That's being unsealed today. Now, hopefully, something in here is going to relate to the alleged purchase of the K-bar sheath via Amazon that supposedly happened while Mr. Kohberger was still living in Pennsylvania. He supposedly ordered via Amazon K-bar sheath, sharpener, and a K-bar. And that was going to be evidence introduced at trial to connect that sheath that was allegedly found on the bed that we have never seen next to Madison and Kaylee on November 13th, 2022. And we know that there is an issue regarding chain of custody regarding that sheath, which I would love to just take a little sidebar time to talk about. The sheath was supposedly recovered by Idaho State Police, right? Because Idaho State Police is who was invited in to process the crime scene. They collected a bunch of physical evidence. It's in the ISP documents from November 13th, 2022. There were numbers placed next to that physical evidence. Item number 11, I believe, was the K-bar sheath. Now, Idaho State Police, even though they would go on to conduct the forensic processing of that evidence, did not take the sheath with them. For reasons I still don't understand, because as we know, law enforcement says after 48 hours, the trail starts going cold if you don't have a POI or a suspect, and they were already 8 hours behind the ball because the crime supposedly happened beginning at 4 o'clock in the morning, but the call to Moscow Police Department didn't happen until 11:56, and we saw with our own eyes that Nunez didn't arrive on scene until noon. So I would have thought, oh my gosh, the sheath on the bed. We know what the weapon is that caused these injuries. Let's get this immediately to Meridian at the Idaho State Police lab. No. What the Idaho State Police did when they were exiting after the first day of processing the crime scene, the morning of the 14th of November at about 12:10 to 12:17, they took all of the physical evidence and they turned it over to the Moscow Police Department via Detective Brett Payne. Detective Brett Payne took possession of that sheath given to them by ISP. And then I have a presentation that I did a while back. It's called 3 Days in Moscow. And that relates to the 3 days that sheath spent in Moscow before the ISP turned up on the 16th to pick it up and to bring it to Meridian. And it was tested on the 17th of November, 2022. If you see those photographs that ISP dropped on October 31st, first images ever of the sheath, unfortunately not at the crime scene and not within Moscow Police Department's possession, it was dated the 17th of November. That's when they did the forensic testing on that sheath. That sheath is the case. I've had many conversations with many people. And I disagree. Joshua Hurwitz did an interview last week. I recommend that you listen to it if you haven't already. He said quite a few interesting things, whether you agree with them or not. He said, for example, that this case was never going to be a federal case based on what it was, what the facts were. It was going to be a state matter, but Moscow Police Department, he congratulated them for looking to the feds because they were too small to possibly be able to sift through the evidence and conduct their investigation. So Christopher is asking, why was the sheath even admissible? Yeah, I don't know. We're looking for the chain of custody from the 13th, from the moment that ISP turned over that sheath to Detective Brett Payne at approximately 10 a.m. through 12:17 a.m. Then they left. ISP left. And what Detective Payne did thereafter, Moscow Police Department did not release a chain of custody for the sheath during those critical days of the 14th of November, the 15th of November, and until the 16th of November when, ISP Lieutenant Walliford turned up and picked it up, and then he gave it to somebody else who took it the rest of the way to Meridian. Oh, also, the regular evidence person for the Moscow Police Department who would have handled the evidence, made sure that it was taped up, that initials, that it was no chain of custody would be broken while it was in the possession of the Moscow Police Department, happened to be on vacation that very week. So there was a stand-in, somebody that wasn't when you go on vacation, if you're out sick, somebody else has to come in and do your job for you. That was the situation here. And there's documentation from the Idaho State Police where they say we have a little bit of a problem. We've got, the stand-in person, the person who's replacing the regular person of all times when this 4-person unaliving happens. We're trying to give them direction on proper procedures. We may have an issue. We'll see when the sheet gets here. That was a notation from November 16th while the sheet was en route from Moscow to Meridian. Then when it turned up in Meridian, the Idaho State Police, the lab, one of the people there had made a note that the sheath turned up in it was like a paper envelope or something, paper bag. It didn't have evidence tape on it. It didn't have initials on it. That's how it was transferred to the ISP from the Moscow Police Department. So I'll leave you to your own conclusions. As I said, I've done a presentation called 3 Days in Moscow going over the missing chain of custody. I don't know why this wasn't raised as an issue. Chain of custody is everything. There was no motion in limine regarding chain of custody. That's where I expected to see something. Chain of custody. We're going to raise a motion in limine, Judge. We want you to make a pretrial ruling. We think that there's a problem with the motion in limine. Number one, the person who was the evidence tech happened to be out that week, and there was a stand-in, and ISP had said that there were some problems. It turned up at ISP, not with evidence tape on it, not with initials on it. They had to put the evidence tape that you see in the documents that were dropped, the photos that were dropped of that sheet in Meridian at ISP the day of testing, November 17th. There's a photo of initials and evidence tape. That was not placed on that bag in Moscow. It was done in the ISP lab when they received it. Even one of the representatives from the Moscow Police Department, Sergeant Blacker, he had made a notation that there was an issue regarding the fact that it didn't have evidence tape and that it wasn't sealed when it left the Moscow Police Department. Yes, 3 days in Moscow, Sonic. Okay, Legendary, good to see you here. Happy holidays to you as well. That should shut the entire case down. That is a critical path, says Christopher Bond. Christopher, I do not know. It's almost standard that you attack chain of custody. You look at any other big case, they're going to raise it because there's, points. Chain of custody is that sheath found on the bed, 3rd floor, allegedly, processed by the Idaho State Police, given to Detective Payne, going to the Moscow Police Department, supposedly. I don't know if, like in the OJ case, the detective kept the evidence in his trunk overnight or something. We don't know. And then every step of the way until it got to ISP to even be processed, there could have been contamination. There could have been a break somewhere. Someone could have, gone in and out. We saw how many people went during the videos of the body cam footage. How many people from Moscow Police Department had to go check those bedrooms? Wasn't the first officers who went in there and confirmed that there were 2 people unalived in Xana's room, 2 people unalived in Kaylee's room. The perpetrator was not hiding in a closet, was not on scene. Why did they need more people to continue to go up and back? Lanier, Snyder. Okay, well, Snyder took some photographs, but does he have to take someone with him when he's doing that? I mean, how many times did they walk in and out? Contamination of the crime scene, I would have thought would have been a motion in limine. We had no idea how many people walked in and out and back and forth. Look at Smith, Corbin Smith, one of the first responders. He's told to watch that back door so that no one goes in. What does he do? And that's supposed to be the point of entry. He is going in and out of that door. The point of entry and exit per the state of Idaho so many times. He's in the kitchen like it's his conference room. He's conducting meetings with at least 3 different people there. If you're cold, put a jacket on, but stay outside. Usually what law enforcement will do to keep contamination at a minimum is to seal off that crime scene and make just the barest of people have access to it. Because whether we like it or not, we drop DNA all the time without knowing it. We drop our hair, skin cells, tears, sweat, fingerprints, and we also take DNA with us. They're walking around without booties on. Yes, they're gloved, but it's the same Moscow Police Department gloves. So when they're going into Xana's room and touching things and then going into Kaylee's room or the great room or the kitchen, that's possibly contaminating the crime scene by touching it. They should have had booties on. They should have had disposable gloves on, like we saw when the ISP showed up later on to process the crime scene. I would have imagined, now having seen all these videos of the first responders, I don't know why. And I'm giving my opinion. I'm giving my opinion here under the First Amendment as we do. There wasn't a motion in limine regarding contamination of the crime scene before ISP ever entered that property as they did at 5:30 p.m. and began to process the crime scene. When you go back and look at those videos, you bear in mind that from 12 o'clock, when, of course, Nunez had to go in, and I could see Warner having to go in, but once they cleared the crime scene, why are all these other people going in? It happened throughout and then why are they taking Murphy out? Was that something that Gunderson checked with ISP and said, we have a living animal in here that we found? He is in a bedroom. There's a crate in there. He's docile. It's not like he's, jumping up and down and being uncontrollable. You see the first image, you see him under the desk. There was a crate in there. There was water in there. There was food in there. He could have gone out in the balcony if he needed to do his business. Why was he removed from the crime scene? Couldn't it be possible that everything that needed to be done to solve the case could have been found on Murphy's coat or on his paws? Maybe not. But don't you want to exhaust that potential? So we're seeing here, hey, charm free, better late than never, better late than never. And then 95 Blue Devil says, my children know not to walk through my mopping, much less a crime scene. Very good analogy. Very good analogy. 95 Blue Devil. Charm Free is chiming in here. Okay, and then we see Christopher Bond. Every single video I've seen of body-worn camera on these cops' 2 channels, they always lock it down super hard, aggressively even. Yes. Yeah, I've watched hundreds. So have I. I'm glad that you are confirming what my research shows, is that if this were like in Los Angeles, I'm following this new case starting this past week of Rob Reiner and his wife, Michelle Reiner, found unalived in their house. Do you think that LAPD would have allowed, dozens of people to walk through that property after they confirmed that the perpetrator was not on scene and that there were 2 unalived? I don't think so. I don't think New York would have done it. I don't think Miami would. I don't think a lot of small towns would have done it. I don't know why so many people were allowed to walk back and forth, up and down. Are they thinking if they go up into Madison's room for the 9th time that they're not going to find 2 unalived? They're going to find the perpetrator hiding in there somewhere? I don't understand it. And I don't understand why defense counsel did not file a motion in limine regarding possible contamination of the crime scene, and also did not file a motion in limine possibly for a chain of custody break. Now, had this case not been so super secret and some of this information released to the public as the case went on, we might have been, as the public, discussing this a year ago, a year and a half ago. We have to find out after the fact, after the case is closed. And we're now, it's almost 6 months. He pled guilty July 2nd of 2025. The Moscow Police Department, the state of Idaho, their position is that it was one person and one person only who committed these in a very tight time frame. Although the affidavit of probable cause says it's from 4 o'clock to 4:25 a.m., we know it's much less than that, because on the top end, Suspect vehicle 1 is still seen until approximately 4:07 a.m. So we're going to cut off 7 minutes from the top of that time frame and possibly a little bit more time because the car had to park. The intruder or intruders needed to get out if suspect vehicle 1 is even associated with this crime. Walk up to the house that might have been going on 4:08. And then to be seen speeding out of the neighborhood at 4:20 in a few seconds. Who's still in the house between 4:20 and 4 and the time that it took to get to the car to be seen on camera speeding out of the neighborhood at a high rate of speed at 4:20? Who's in the house from 4:19 to 4:25, the end of the timeline, still committing crimes? All right. Now we see finally with the last batch of documents that were unsealed, and we don't see the autopsy reports, but we see a synopsis from the state. And that's when we found out some of the brutality. Just on Zana, there were 4 victims, 4 precious victims who we always remember and who I believe deserved a top-notch, top-quality investigation. Kaylee, Madison, Zana, and Ethan. Look at how many times the state is saying that Zana was struck. How long would that have taken? There was a struggle in that room, supposedly, per the state of Idaho. Now add on 3 more victims. Could that possibly have been running up and down the stairs? Going past a pong table, walking down to Zana's room, and then leaving. Could that have been done in a matter of what, 6 minutes, 7 minutes? And then not dropping any DNA? Except for what was allegedly found in the sheath that the public has never seen yet, except for what Meridian dropped several days after the crimes in their lab that came to them like a peanut butter and jelly sandwich instead of the key piece of evidence in this case in a brown paper bag with no evidence tape and no initials on it. 101 stuff we're talking about here. Okay, so they say one person did this within about 6-7 minutes of time, did all this destruction, didn't drop a ton of evidence, didn't leave with a ton of evidence because they didn't find anything in his apartment, his car. And they took that car apart. If you've seen the photos that ISP dropped several months ago, you know that they did what we've heard, that they will go down into the floorboards. They took that car apart. How good must he have been to be able to keep every piece of DNA? What? Did he have some sort of uniform on or protective device that acted like kryptonite to Superman, and DNA was afraid of attaching itself to him? They're saying 6 minutes of time that all of those crimes were committed by one person. I don't know. I'd like to hear about you. He's a wizard. Charm Free is saying he's a wizard. He's a wizard. Hi, Amy. Glad that you're here. Christopher is asking, was ISP even on scene at that point? Moscow was in control of the scene the moment they didn't have to check in with us. Well, what had happened from what we know from the ISP documents, which I believe were a lot more professionally put together than that's just my opinion. The head of ISP had stated the document number 1, first batch of documents that were released by the Idaho State Police, says that Moscow Police Department contacted them at 12:22 p.m. asking for their help. You see them on the body cam footage pulling up. It was somewhere around 2:45 or something with their big van. They parked it in front. But it doesn't look like they went in because they were there to process the crime scene. And in order to do that, they needed a warrant to be able to go into someone else's house and start taking things out of it. The warrant that when you see Mitch Nunez leaving, we now know that what he did is he went back to the Moscow Police Department and began working on the warrant. And it was sent to magistrate Marshall, probably. She signed off on it. And then 5 o'clock, you see the 5 people after the warrant was signed who went in. 2 members of the prosecution team, Thompson and Jennings, did both of them need to walk through that crime scene? I can understand that one of them wanted to see it, just like Mr. Kohberger's defense attorney, once she was retained, went in to see the crime scene so that she could help to defend him. Okay, I could see Bill Thompson going in, but does he got to take Ashley Jennings with him too? And why do you have Brett Payne and also his colleague Blacker going in with the head of ISP? 5 people walked through that crime scene at 5 o'clock. 5:30 is when they started doling out. Okay, you're going to do this. You're going to take the photographs. You're going to process Anna's room. You're going to process Kaylee's room. You're going to process. That's when all of that started happening. 5:30 is when they started to process the crime scene. And it continued on until 12, a few minutes after 12, the morning of the 14th. That's all documented with the ISP records. Legendary is saying a fried bologna sandwich. Christopher is giving his opinion here. I've said in the past that if he did it, he still needs to keep him out of the prison so that they can study his abilities. That's a good point, because quite frankly, I'm not here to say he didn't do it. He didn't have something to do with it. Maybe he did. I'm not, I don't even know. I don't know if he didn't. We won't know until the evidence is unsealed to the public. That's when we should have learned that at trial, but unfortunately the trial was canceled, as it was July 2nd, 2025. And here we are, nearly 6 months after he pled guilty. And only today, the court's getting to documents from January of 2025. Until today, these documents from January, February, and March that have been unsealed, with others still under seal, weren't released to the public. How long is it going to take him to get to the beginning? Oh, and then he's got to circle back and address the many documents that have been under seal after the case closed. So in other words, he's starting from July and June, working back with that first court order, but there have been several things that have been filed under seal after July, up to and including yesterday, when he entered that court order regarding the state of Idaho's objections to certain of these documents being released to the public. And however many more things are sealed by the time he gets to the beginning of the case. And that is December 29th, 2022. That is day one of the case, when the affidavit of probable cause was signed asking for the warrant. The warrant was issued that day based on the PCA, and he was arrested the next day. I'm saying we might be going into 2020, end of 2027. I thought maybe 2 years for the whole thing. I'm thinking it's going to be more like 2.5 years at this pace. Okay, Amy is saying, I always said that Judge Hippler never reviewed the Latah files. Let's consider this for a second. What did he say? All right, you remember back in July, there was a hearing. The media coalition came in and wanted the entire case unsealed. They said, Judge, look, Kohberger has pled guilty. You don't have a worry now anymore about possible prejudice of a jury. First Amendment says the people have a right to know what's going on in this case. Unseal these records now. And that's when Hippler said, he denied it from the bench. And he said, I'm going to start a process unsealing the documents a bit at a time. And I'm starting it from the end because those are the records, Amy, that I am more familiar with. So what Amy is saying is she questions if he's even read the file. The file had to have been ginormous by the time, and it was Mr. Kohberger's motion for change of venue. He filed it at the end of January 2024. It was granted in September of 2024. Kohberger, the transfer happened mid-September 2024. So it's like from the beginning of the case, how much information had to be there from the 29th of December 2022 to mid-September 2024. That happened even before Hippler was named the third jurist in the case. Sonic is saying multiple perps organized. I always was actually scared after I saw the undercover cops at Banfield shaking down the kids across the block. in the white sedan wearing black type uniforms. That's, how many other times have we heard of, and it's unfortunate, I wish this wasn't this way, but multiple unalivings happen every day in the United States. Sometimes there's mass. There was just one this past weekend at Brown University where multiple people were wounded and unalived. 3 actually, because they're saying now the professor over at MIT was also related. So this happens every day in this country. How many times can it be said that an undercover cop car was steps away from where the unalivings happened? I've been studying true crime. I've had an interest in it dating back to the 90s, and I can't remember one scenario. Could you just imagine the OJ case? It's called the trial of the century. If it would have come out that there was an undercover LAPD car steps away from the entrance of Nicole Brown's townhouse there in Brentwood, or an undercover car was on the same street in another part of Brentwood where 2 people were unalived this past weekend. Rob and Michelle Reiner, highly unusual. White sedan, that's what suspect vehicle 1 was called many times during the investigation. What about when they put out the bolo to be on the lookout? They didn't include a picture of the actual suspect vehicle 1 that they said that they had at all angles on all of these videos that they put together, not just from the 1112 camera, but all sorts of camera. On the way to Pullman, from Pullman, there was not one image of the real suspect vehicle 1 put in the bolo. And it didn't sit well with me. I said, why are you hiding this? You're releasing nothing. You're clearing people that might have been considered, at least, not throwing shade at anybody at all, but might have been considered persons of interest, last people that were with them, significant others, people there might have been, might had to look into a little bit more detail before cleared. But that bolo, when it was released to the public in early December 2025, and we saw there were 2 stock images that they decided to use, one with a sunroof, one without a sunroof, and not, even if it was blurry, not an image of the real suspect vehicle 1. So it seemed like there's too many things that were, and now seeing how many people walked through that crime scene, now with the questions regarding chain of custody, now finding out how many injuries, like we heard they were asleep, or at least in their, no, they weren't asleep, at least in their beds. There was a struggle, it sounds like, from 2 of the victims, at least. So how is it possible that one perpetrator could have committed this within 6 to 7 minutes, not dropped a ton of DNA, not taken DNA with him? But this is what we're told. It was one person. There was no accessory before the fact. There was no accessory after the fact. There was no co-conspirator. There was no alternative perpetrator. We need this file, all of it unsealed. We need the images of this sheath on that bed released to the public. We need video of the first 5 first responders. None of them mentioned a sheath in their reports. Come on. I mean, was it that hidden? But then it's supposedly you can see it from the door. According to Detective Payne, if you can see it from the door, why did the 5 people who entered at 12 o'clock or just a few minutes after, why didn't they see it from the door? Why didn't Schneider's photographs inside that room, where he's so close that he's seeing lividity, didn't notice that sheath? Why is his photographs, why weren't there 20 photographs of the sheath with descriptions? Because we haven't seen them yet. They're under seal, a lot of them, except for the first ones that were released by the media who got a hold of them a couple of months ago. Why weren't there descriptions in his report of a sheath from the left, a sheath from the right, a sheath from overhead, sheath underneath, sheath standing from the door, sheath standing from the window, sheath from above. That's what I expected. Blueberry, hi, welcome. Good to see you here. Blueberry is saying that Molly described a sedan and that they made a trip in tan SUV because the tan sedan actually describes the undercover police officers. Okay. Hey, Heather, good to see you here. Heather is saying that because all the CCTV footage shows different cars. Blueberry is chiming in. We need a grand jury indictment for the judicial system and the officers over in Idaho. Sonic is saying in previous police interactions at the 1112 house regarding noise, etc., I picked up a weird vibe from which one, Sonic? You picking up a weird vibe? Because someone had suggested they would not be surprised if there were more noise complaints for that house. Then I believe we have two that have been released to the public. The one that happened when, I think it was September 1st, the late evening, September 1st, beginning of September 2nd, when Zana came to the door. And then we have the one, very strange in my opinion, where there was a noise complaint called in, not for 1122 King Road, but for the frat house, where the off-campus frat house for the guys around the corner, where it was a heavy-set cop and one of the Banfield cops who reported, who didn't I don't even think he asked a name of the people who he spoke with, much less asked to see ID, much less took a photo of ID, and he left there. And then he decides to make a beeline for 1122 King Road because he saw supposedly a boombox. Nobody called in a complaint that day for 1122 King Road. He decided he was going to walk around. He bypassed the front door altogether, proceeds around the back, starts knocking on the slider. Kaylee comes out. Hunter is with her. Hunter has zip ties on his arms. He doesn't even ask Hunter his name. Turns to Kaylee, asks her, remember, no noise complaint was called in here, like there was around the corner at the frat boys off-campus house. No noise complaint was called for her. He's asking for her, taking her ID, taking a photograph of her ID. Is that the one you're speaking of? Yeah, that one. Okay. So anyway, ladies and gentlemen, I just wanted to get on today to go over this finally, this order unsealing some of the documents. And I really like the fact that Judge Hippler overruled one or both of the parties in quite a few of these documents that they wanted, one, the state or the defense or both, is how this order says. And he said, nope, I see no reason to continue to seal these documents. Now, would I have liked to see every single document unsealed? Yes, I would have. I think that would have been full transparency. Would I have liked to see these documents not sealed back when the case was progressing? Yes, I do. I agree with the media coalition and one of the investigative journalists who submitted a declaration in support of unsealing the documents back in July, she said this is the most sealed case that she has ever seen, words to that effect. She said she felt it was oversealed, it needed to be unsealed, and she addressed the First Amendment issues. I think that these documents shouldn't have been sealed as much. There was in my opinion, that I give under an over-sealing of information, and I still can't figure it out why. When you consider the fact that, was this over national security? No, it was not. Tragic as it was, unalivings happen every day in the United States, sometimes multiple. The cases are not sealed like this one is. One right time where they kept getting the runaround about the yes. He's fulfilled his debt. And now he's being okay. So Christopher is saying, well, maybe now Hippler is starting to be fair. 95 Blue Devil is quoting Hunter, aka Homeboy, as referred to by Officer Warner. I'll tell you, of the first responders, and I'm just giving my opinion. It doesn't mean anything. It's just my opinion that I give. I think he conducted himself most professionally of all five. Now, I think he walked in and out of the house. I mean, he was one of the first two responders. I don't know why he's walking through the house to go have a conversation later on with Officer Smith in the kitchen, where there could have been evidence of a crime. We know that the backslider was the front and supposed to be the point of entry and exit. Why are you hanging out in the kitchen? Why aren't you outside? So I got to give the merits to Warner on that one. But from the moment he left the Moscow Police Department, his body cam is on. And it is on until he's off duty. Can't say the same thing about Snyder turns up without a body cam on. Can't say the same thing about Sergeant Gunderson. Body cam wasn't on when he's arriving at the crime scene. Can't say the same thing about Officer Smith. He didn't have his body cam on from the time, or in his cruiser from the time he left wherever he came from, coming to 1122 King Road. It was Officer Warner who had the body cam on at all times. Sounds to me he wants to make sure that everything that he does is caught on camera. You can't make any assumptions about anybody. That's what I feel. And he did. He called Hunter homeboy in the kitchen. Homeboy is out there with a, yeah. Sonic is saying the sheath doesn't fit with evidence tape on it. You must acquit. Okay, so Sonic is coming up with a term, and I believe it's Saturday, right where you are, Sonic, if I'm not mistaken. Sonic says the sheath doesn't fit with evidence tape on it. You must acquit. Going back to the infamous Johnny Cochran line from the OJ trial. Yes. For 95 Blue Devil, I thought the same thing. When I looked at those interviews, why is Homeland Security involved in this? He did some interviews right away. Thank you for giving the timestamp. Anyone else, if you want to take a look, I also did some reviews on them and asked the same question. It's ISP timestamp 0008. We're talking the day after, early on in the investigation. Yes. Okay, Sonic. Well, I would. I do not blame the Moscow Police Department one bit with that first call, because here they come. Their noise complaints were called in, so they turn up, and a woman who was out in the parking lot that they spoke to for a few minutes, who was leaving, looked like one EB, known as Bonnie and Clyde. She's walking away as Moscow Police Department is walking up to the front door. Moscow Police Department knocked. I mean, you hear the music. The window's right there. It's just a few feet over their head to the great room, and it is open, and the music's coming out. They're banging on the door. Moscow Police, Moscow, anywhere else, I don't think that they would have been that patient, because it took several minutes before Emily opened the door and said, just a second, close the door. You expected a minute later that one of the residents of the property would have come. Nope, it's several minutes. They start knocking again. And the people are hanging out the window of the second floor, for goodness sake. And they were like, open up, open up, open up. And finally, when HJ comes to the door with the other guy, he says none of the residents are home, but there's this big wailing party that's going on. And the officer said, well, should we, are you trespassing then? Rightfully so. They finally got Madison on the phone. You can hear that conversation. And then it was a few hours later, the same night, only it was then the early morning hours of the 2nd of September, where they returned. I swear it's Payne who's talking to Xana. I may be wrong, but it looks like it's Detective Payne who returned that second time. Christopher is saying, Kathy, do you realize the audio is entirely out of sync by a few seconds at the beginning? Rosie's knocking happens audibly before he even gets to the window. I didn't look at it that quickly. What I do know is that when Kaylee opens the door and comes out, she's saying, oh, we knocked at the front door. You didn't come in. No, you didn't. I mean, he is on body cam, walking past that front door, going to nobody knocked on the front door. They knocked on the back door. The other cop got into a conversation with a student out front, but nobody knocked on the front door. And if they're going to tell that type of a fib when they know they're on body cam, you didn't knock at the front door. He's making like they ignored his knocking at a front door for a noise complaint that never happened. The car park door. Yes, the front door. The front door to the property. Like when you walk in, and you're sounding quite British, I must say, because the Brits do say, we say parking lot, you guys say car park. Yes. What they do is if you watch that body cam footage from the beginning, you see them leaving the frat boys' house where the noise complaint happened to go and investigate a house where there was no noise complaint. And you didn't hear loud music as he's from around the corner. His reason was he saw a boombox. So he decides he's going to walk around and confront the residents of 1122. They bypassed, nobody knocked on the front door, not him, because he went right, made a beeline for the back of the house. The other cop stopped to talk to a kid that was out front, a student, a male who was out front. Nobody knocked at the front door. Why are you saying you knocked at the front door when you didn't? Right. Christopher, you point out such an important topic here. They didn't even have a specific complaint for 1122. They just lumped it in on top of the complaint that they had, and they treated the residents very differently. Go back, Christopher, and take a look at how they treated the males. Didn't ask their name, didn't ask for ID, didn't take a photo of an ID, came around, totally different situation. Didn't ask Hunter his name. He's standing there with zip ties on his arm. Didn't ask, who are you? What's your relationship? What do you want? Didn't ask his name. Took Kaylee's identification, looked at it, took a snapshot at it. Didn't even have a complaint for that house. And then they start, while they're waiting for the residents to come out, they're making comments about the back of the house, saying things like, do you remember when they said this, Christopher? Oh, look up there. Look at the balcony. There's no stairs leading up to the balcony. That's odd. And they're making a notation about the windows. And so, you aren't even called for a noise complaint for that house. And they're making all of these observations about the house. Yeah. Treated the males very touch and go. I agree. It was a weird vibe, Sonic. I agree with you. Yes. Okay. Christopher is quoting, that's curious. No stairs to the balcony. End of quote. And that's true. There were no, that I have said, I need to see more evidence to persuade me that the point of entry was the back door. Where I'm at right now, the point of entry could have been a window. The point of entry could have been that balcony with the sliding glass door. Supposedly it's the third floor from the front. From the back, it's the second floor. There's a couch there. If you're a young person, especially if you're in good shape, they could scale a little bit. They could jump. They could, jump up to grab and then haul up. Could have been the point of entry, the third floor balcony. The front door. Even Jack D said, too many people have the code for this house. The last time that front door was serviced was like 2 years earlier. All of the residents who lived there the prior 2 years before the group moved in 2022, they didn't change the code. It was the same code. And then they're giving it out like Halloween candy to all of these people. And who knows who they gave it out. If you give it out to one person, you got to assume maybe that person gave it out to another 3. And it wouldn't have been real hard. It wasn't like it was a bolt, a real strong lock. It looked like if there was sufficient force on it that it might have been able to be kicked in. And then I say, maybe that's what the surviving roommate heard and saw when she saw a light flash and a bang coming from the first floor. Her door doesn't face the front door. Her door is way down the hallway with the stairs separating her from that. How is she going to be able to see light coming in from the front door if she's not facing it? I've made a theory, maybe that's what she heard and saw. Okay, so Heather is saying DM seems to think the balcony door was used. That is interesting. Scale up in a second, right? So now I couldn't in my shape and at my age. You got to be kidding me. Scale up 6 inches, much less several feet. But if you're in good shape, wouldn't be that hard. And then you got a couch out there that you could possibly position to help you get up there. Okay, CAO Kane is saying it sounds like a flash grenade. That could have been it. It could have been another weapon. Do you guys remember the early interviews of the G family, Kaylee's family, where they received a call from Moscow on Sunday, the 13th of November, from a family member? And the first report was that Kaylee was unalived in a mass event like the one that just happened at Brown University. So the idea, maybe it's a flash grenade, maybe it's something else, another type of weapon. We need to see the documents unsealed. We got to see this case unsealed before I'm comfortable with knowing that he was the sole perpetrator or he was involved in the crimes. We don't know at this point. Send someone out who works. Lives here. Yeah, CAO. They're saying massive damage. Remember the image that was released that had to have been taken by Officer Snyder because he was up there, followed by Gunderson at around 12:25, 12:28. That's when he was standing outside of Madison's room. And one of those photographs was released by the media who had gotten, I think they have all 182, 188, however many images they are, that he took outside of the house, inside of the house, and in both of the bedrooms. That one photograph, I wish I didn't see it. It looked terrible. And you don't even see, you see, it looks like the outline of her, but you don't see her face, but there's red DNA that it just looked like, from what the family said, the damages were different. Happy holidays to Amy. Everyone is saying happy holidays. Nice. Amy is saying on the new audio on Outcast, you can clearly hear a young man yelling at Kaylee, telling her, it made me cry. Oh, I don't even want to hear that. Oh, don't want to hear that. All right, guys. It has been great that you've joined me today as I celebrate finally, after day 64, of the release of Judge Stephen J. Hippler's court order relative to the third set of documents. Now we have to keep our eyes peeled on the docket for the fourth order, because that will finally get matters into 2024, the end, when Judge Hippler starts the process all over again. I'm going to go back, take a little break, go back, look at these documents, and I'll have some content up over the weekend. So please, if you haven't already, subscribe to the channel. Please like our content. We'd like our channel to grow a little bit more, to get out the facts, not the fairy tales about these true crime cases. Miller Time, thanks for joining us. Everyone, have a great holiday. Happy holidays to you, CAO Kane. Thank you so much, Sonic. Go over the documents. Sonic, please make sure you have both of those orders opened, because that way you can go down and you can correspond the number to what the document is and then go on to the docket. I know which one I'm heading for right away, and it has to do with, I'll give you a big hint, AT&T timing advance records exhibits from the in limine briefings. All right. Hey, Amy, I'm going to grab a cup of that coffee. I thank you very much, everyone. Please like the button. Please. Thank you so much. Document number 121. Christopher, you and me both making a beeline for that document. We'll have some content out throughout the weekend. We're going to keep our eyes peeled for court order number 4 relative to the 2014 finally documents under seal. Everyone, thank you for being here today. Thank you for keeping the interest up in this case. I believe that your interest, the interest of other content creators, independent journalists is what is putting heat on to get this documentation released to the public. Mainstream media isn't. They're reporting on stupid things, in my opinion, things that make no sense at all, i.e. what BK is wanting for Christmas dinner in prison, when we have a case of this magnitude that's been under seal for more than 2.5 years and evidence that's been released that doesn't seem to make sense. Ladies and gentlemen, thank you so much for joining us here today. Enjoy the rest of your day, morning, noon, night, wherever you are, and we'll see you again soon. This is Kathy. Thank you for joining us here today.